views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of Bronxnet or the program underwriters.
All right, coming up on this edition of Today's Verdict, many employees face dangerous situations at work that result in lifetime injuries, but you do have rights that are guaranteed by both state and federal law. Today we look at workers' safety and protections every laborer should know about. Next, wrongful death is an action that is brought by the estate of an individual who has met an untimely end. It is a difficult situation for the estate to endure, with many time limits that must be met. We guide you through the difficult process of negligence that can turn to the worst of possible scenarios. And do you know what mandatory arbitration is? Well, you might have unwittingly agreed to dispute your arbitration when you signed a contract and did not read the fine print. But don't worry, we have you covered as our guest in studio guides us through all things arbitration. Well, as you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. All right, hello and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesch. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us at Facebook at Today's Verdict and check us out at Bronxnet.tv. Well, employees often face dangerous situations that can cause a lifetime injury. But employers, whether private or public, are responsible for workers' safety. Here to tell us more is attorney David Oddo, the attorney who is also the new president of the New York State Trials Association. And we want to thank you very much for being here, David.
Thank you, David.
First, let's talk a little bit about you. Okay, I know the kind of work you do as a trial attorney, but also as the president of the trial lawyers. Tell us a little bit about yourself, if you could.
Sure. I'm a partner with the law firm of Okun, Oddo, and Babat in Manhattan. I've been in private practice for about 26 years, 27 years or so. I started out as a trial attorney in the Nassau County District Attorney's Office, where I prosecuted criminal cases. And now I concentrate my practice in the trial of medical malpractice cases, general liability, and other personal injury matters.
That's why we're going to pick your brain about a lot of very interesting topics. But let's talk a little bit first about the New York State Trial Lawyers Association, NISLA, as I know it, as many people know. Let's talk a little bit about the organization, if you could.
What we do at NISLA is we work to enhance and preserve the New York civil justice system, basically. And the way we do that is we fight to assure that every New Yorker has full access to the courts. We believe, as most of us do in the bar, that the right to a trial by jury and the right to access to court is a fundamental right that we all have.
And the organization provides different programs and lectures and different things to the public and attorneys as well, am I correct?
Yes, we promote education through continuing legal education courses. We are the top provider for continuing legal education in the state of New York.
All right, let's get into it. All right, I want to talk a little bit about worker safety. So many of the viewers do have relatives or themselves are working on different construction sites, which unfortunately do result in certain types of injuries. What are the types of things that could happen or that can go wrong? Because there's been a boom in construction in the Bronx, which has been a good thing. But safety is important, more important than anything else. So tell me some of the things that you've seen in your practice as a trial attorney in terms of workers and injuries that occur.
Sure. I think the most important thing for your viewers to know is that if you're working on a construction site and you're working at a height, the owner or contractor has an absolute obligation to provide safety equipment to you and to provide a safe workplace.
Now, when there's a job that's being done and there's, let's say, a building's being erected somewhere in New York City, right? You have a general and you have a subcontractor. Who's responsible, really? Are they both responsible? How does it really work in terms of who's the one who's supposed to make sure that you're protected?
That could change. That
Okay.
answer could change depending on the different factual scenarios. You could have a situation where both. You could have a situation where one. But the bottom line is, when you're working on a site, whoever is responsible for you and for your safety has to provide that safety equipment.
What type of protections? What are they trying to? What do they have to give you?
Sure. We're not talking about high-tech stuff. We're talking about harnesses, ropes to tie off ladders, proper planking on scaffolds, things like that.
And do you find that either the wrong equipment's being given or no equipment's being given?
I think for the most part, it's no equipment is being given.
All right. Okay. So let's talk about this labor law type of case that you're going to have. What do you do? I mean, is there a certain amount of time that you bring the action? How does it generally work?
Yeah, anybody who's injured, either at a workplace or otherwise, has to be very aware that there are statute of limitations. There's a time limit for you to bring your case. And in general, negligence cases, such as a worker's case, you have 3 years. And it's very, very important that, and that could change, because if you're working, if it's a municipality, that is the tortfeasor or the wrongdoer, you have less time. So what's very important for your viewers to know is that if you are injured, okay, you need to see a lawyer immediately to determine what the statute of limitations is in that particular case.
And also with, if it's a municipality, you have that, let's say, a notice of claim. You only have 90 days to let them know that this construction site has created some type of difficult situation for you.
That's correct.
All right, so now you're ready to go. You're gonna try your case, or you got everything ready. What do you use to prove your case when it comes to a labor law type of action?
Well, it's similar to other negligence cases in that you call witnesses, okay? Witnesses to the actual accident, witnesses to any issue in the case. You also will call experts in the field of safety, and you will call medical experts.
Do you find that the jurors are receptive to these types of cases? There have been cases that ebb and flow. Sometimes the jurors aren't as loving of the automobile accident case. Yes, maybe on a sexual harassment case, they are more giving. It depends on the, on the way things are in the papers and in the media. Do you find that juries are sympathetic to the worker? In your experience as a trial attorney?
I think they're extremely receptive to it, and they're receptive to it because most everybody knows someone who has worked in the construction field or has, and can appreciate the fact that people go to work, do a physical labor to earn a day's pay, okay, and want to come home to their family and be safe.
Okay. Any tips that you would give to somebody maybe who's watching, who's unfortunately has already been injured, okay, at this point? What would you say to somebody who's been injured on a site, on a work site, whether it's reports or police? I don't know. What would you tell them?
Well, if it's a work site that's being run by a reputable company, there would be a report, and there would be someone to report to, and there would be someone who would take all the information from you.
Okay. And by the way, I hope the trial lawyers, do they give classes on labor law and educating the public?
We do. We have many a CLE on the labor law.
Okay. Don't go. We're gonna pick your brain because we have a lot more we have you for the full half an hour, so don't go anywhere. We have to take a quick break, but don't worry, we'll be back with more Today's Verdict right after this. Hi, welcome back to Today's Verdict. I'm your host, David Lesch. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Well, we're back in studio with David Oddo. David, sometimes the labor law accident cases do result in something that's called a wrongful death. It may not be labor law. It could be medical malpractice or anything, any form of negligence that results in it. Tell us what we mean when we say there's an action that's being brought for wrongful death.
Well, unfortunately, in New York State, it really only means one thing. The family of the person who has been killed through the negligence of someone else is only entitled to economic damages. And there is no cause of action for their grief, their loss, their pain and suffering as the result of the loss of a loved one.
All right, let's use the, because we were been talking about the accident work site as an example. God forbid somebody falls from a scaffolding and because of negligence and not providing the proper equipment, and this particular employee passes away, right?
Right.
You talk about pecuniary loss because you know the employee was hopefully providing for his family, maybe his children, his wife, possibly his parents, or if it was a she, it could be a woman who's hurt. The elements in terms of wrongful death, what are you proving here? Is it just an ordinary negligence case, and then you get into the different types of damages? Explain what you mean.
It has both parts. The aggrieved worker is entitled, the deceased is entitled to any pain and suffering that they were conscious of, okay, before they passed, and then their estate, which would be wife and then children, and going into the lines of succession, would be entitled to any economic loss that they would have as the result of the loss of the loved one.
All right, before we get into the economic loss, let's talk a little bit first about if there is any kind of pain and suffering, because many viewers have wondered and have asked, because we've gotten emails, why they cannot recover for the pain and suffering of their loved one as a result of a wrongful death. Certainly if you lose a child or a spouse, you're suffering emotionally, yet the law does not provide you with the means to recover for pain and suffering. Am I correct?
You're correct.
Why? Why?
New York has an antiquated statute, wrongful death statute, which was enacted in 1847, okay, over 170 years ago, which only allows a family or a loved one to recover for any economic loss. The answer to why, I can't answer that. All I can tell you is that we are way behind all the other states. I mean, there are very few states that have this harsh, antiquated law that we have. Because
certainly you do suffer when you lose a loved one based on somebody else's wrong or negligence. All right. However, and tell me if you're the expert here, the decedent may have suffered before the decedent actually passed. Let's say that worker, unfortunately, survived for a couple of minutes, maybe a couple of hours before he actually or she passed away. Can you recover? Can the estate recover for that?
Yes.
All right. So you can recover for the individual's pain and suffering, but not for your own as the estate.
Correct.
All right. It's tough. All right. Now let's get into the economic loss, because now that's a lot of people want to know this, especially the families who are suffering and not able to provide for themselves because they've lost the breadwinner of the family. How do you prove this? How do you even find out, how much you'd be entitled to as an estate?
This is all done through experts. We hire, to prosecute these kind of claims, we hire economists, and the economists will do a review of tax returns, interview family members, get all wage information, wage history, employment history.
Throwing a curveball at you here, but that's okay. But does it matter, the immigration status, illegality, anything?
No.
That's not going to prevent it.
No.
So if somebody, how about off the books? Is that an issue also?
That poses a whole different set of issues.
Okay. But they're still providing for the family, and
Yes.
the estate should be able
Correct.
to recover. All right. Now you got your trial attorney hat on, right? You're in court. Once again, we're discussing the jurors and the sentimentality of these types of cases. Is it a county by county situation? We know the Bronx seems to be a giving borough. What are your feelings on that?
I think it all depends on the actual case. Okay, if you have a weak case, you're going to lose whatever county you're in.
Right.
So if you have a strong case, I think you would be confident as a trial attorney in most boroughs.
The wrongful death, by the way, different statute of limitations.
Yes, indeed.
Let's talk about that.
Yes, and again, that's something your viewers have to be wary about. That's a 2-year statute.
Okay.
And again, you always have to check with respect to notice of claims issues against
So
municipalities.
again, if it's a municipality, something else. All right, now, tips. Someone's watching. Unfortunately, there has been some type of death in the family. We believe it's because of the negligence of a third party, which, let me strike this for a second. Workers' compensation, does that ever prevent you from ever being able to really bring these wrongful types of cases?
Yeah,
If it's against your employer, you wouldn't be able to.
that's correct. There's a bar.
But a third party, if say the third party's involved, you would be able to.
Correct.
All right, so tips. Somebody's watching now, unfortunately there may be some kind of death in the family as a result. What would you tell them to do to protect their rights with respect to wrongful death?
Well, it's very important to contact an attorney who practices in this field immediately because, again, time limits are very, very important to the case. So you should get right on that.
Get right, all right. I'm about to get into some mandatory arbitration, all right?
Sure.
Before I do, we're gonna take a quick break, but again, please, don't go anywhere.
You got it.
All right, we have to take a quick break, but don't worry, we'll be back with more of Today's Verdict, especially discussing arbitration. Stay with us.
How can I help my daughter with her reading?
Searching for help with Dachshund reading.
No.
Let me try. Sarah's bright, but when she's reading, she has trouble sounding out words.
Playing world music.
What?
I give up.
Wait, I was trying to show you how Sarah feels every day. Frustrating, isn't it? Redirecting to understood.org.
Join parents and experts at understood.org, a free online resource about learning and attention issues to help your child thrive.
And I can't change, even if I try, even if I wanted to. My love, my love, my love, she keeps me warm. 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 She keeps me warm.
We are neighbors and best friends.
I love my sister.
My heart doesn't see race. Love is love.
Our family is no less than any other family.
Love is kind. Love is patient.
Welcome back to Today's Verdict. I'm your host, David Lesch. We are back with attorney David Oddo. We're getting into a subject that I don't know too much about personally in terms of the trial work. I don't do arbitrations unless they're really mandatory and the court, or I voluntarily go into it. But I don't know too much about it. When we talk about an arbitration as opposed to a jury trial, what do we mean? Just so we can start from the beginning.
Sure. Arbitration is an alternative to going to court and presenting your case to either a judge or jury. You have an arbitrator, an individual who both sides agree on to decide your case. And it's a less formal procedure where you may meet in an office building, in a conference room, and you get to present your proof, and the arbitrator will write a decision listing his reasons for his finding, and it's binding. Both sides have agreed to live by whatever that arbitrator has determined to be the judgment.
Okay. Now, what I think is interesting is that many times you're forced to go into an arbitration as opposed to what you would think, based on your constitutional right, to a trial and a jury. But you don't always have the right to a trial by jury, am I correct?
Well, you do have the right, unless you've signed your rights away.
That's what I mean.
Yes.
Because listen, we're signing stuff all the time.
All the time.
You know, whether it's Apple contracts that we're Xing off of, or we're buying a baseball ticket, we're always signing something away. And if you think everybody's reading 10 pages of fine print, they are not. And in that fine print is usually sometimes a clause that says, if you have a dispute, you must go to mandatory arbitration. Am I correct?
You're absolutely correct.
Can you do anything about that?
This is more and more we are seeing corporations, well-funded entities trying to take away, trying to strip your right, your fundamental right to a jury, to go to court for your day in court.
Is that because it costs more money to go to trial, or is it because they think they're going to get a better result because they're not so magnanimous, are they?
Well, they will get a better result, and most of the time they will, because in that arbitration, that arbitration contract that you didn't even know clause that was in the contract you just signed, it'll have the name of the arbitrator. They choose the arbitrator, and that arbitrator basically works for them.
Anyway, no. So let's say you sign this document, and you have this particular arbitrator. Is there anybody you can write to change this fundamental unfair situation?
There's a number of things that are going on now. There's at NISLA, we're attempting to support legislation which would basically not allow. Well, let me back up for a minute.
Sure.
What we see, and what we see as the main problem, is not so much. It is in consumer transactions where you're doing it online. Those are problems, and you've signed your rights away. But we find the real main damage is being done in cases where your health care is determinative of whether or not you sign a contract. So, for example, your mother, let's say, is had a surgery, was in an accident, or had an illness, and they're about to discharge her from the hospital, but she has to be discharged into a nursing home or a rehab facility. And you're scrambling, and the family's trying to find a spot, and you find one. And time is of the essence, and you get her to that facility, and they hand you a 40-page contract, okay? And they say, here you go, and you sign it, and you may even read that clause and say, I don't care, let's hope for the best. And you sign it, and what you've now signed is basically agreeing that if anything, God forbid, something happens in that facility, whether they neglect her, whether she's sexually abused, whether they let her bed sores fester, that you have to go to arbitration, and you will not have the ability or the opportunity to have your day in court.
That's horrible.
Horrible.
So what is NISLA doing? What are they trying to do?
Well, I think it's what the legislature is trying to do, and I think hopefully there'll be some traction to this, and that they will prohibit. There will be some prohibitions on these type of contracts.
Some kind of opt out.
There should be
something to prevent you from. It's either A or B. Would you like our arbitrator, or would you like to be able to have a trial by jury? They should, like a small claims action. When you get a small claims court, they say, would you like to see the judge, or would you like to see the arbitrator? They might say, you see the judge only 2 or 3 cases a night. The rest of the time, you'll be here all night. But you could see an arbitrator. You might pick an arbitrator. But that's a small claims court. I mean, this is giving away your right to bring a medical malpractice case. Because you signed something while you're under the duress of somebody being sick in a hospital.
And it's such an uneven playing field. They have a position of incredible power.
It's really not fair.
I know. And there have been instances also, David, you should know too, there have been instances where providers have refused to treat patients until they sign those.
So they stand over you before you actually sign.
That's basically what happens.
Let's talk a little bit about some of the other things that NISLA is doing. Some of the programs, some of the other stuff. Let's talk more about because it's a wonderful organization. They're fighting for the people who don't have anyone to fight for them. The trial attorneys. You walk down any aisle of any supermarket and you look at all the different products and the warnings and all those different things that are on any of those products. They came from trial attorneys like you who were able to get juries to see that there's been a wrong, and as a result, things have changed. And people don't realize that because they don't walk around and look at all the changes, the safety that the trial lawyers have brought. So I'd love to hear some more things you guys are doing.
Well, I'm old enough to remember when Pintos, there was a car called a Pinto that, a little fender bender, the gas tank was placed in a position where the car would explode, okay? Where pajamas used to be made out of flammable material.
Asbestos.
Asbestos.
There's so, I mean, you could talk everything from lead paint.
Right.
I mean, all these things have really come from trial attorneys.
And part of the mission of NISLA is to, by holding wrongdoers accountable, making society safer and healthier.
Okay, first of all, where do we find NISLA? What is the contact for NISLA?
Yeah, New York State Trial Law is located at 132 Nassau Street in Manhattan. And you can give a call if you have any questions or wish to discuss anything. We'll be more than happy to talk to you.
And most importantly, where do we find you? Because I'm sure there are many people who've been watching this segment tonight and would love to know where they can find an attorney who could properly represent them. Go ahead.
I'm located at 8 West 38th Street in Manhattan. My law firm is Okun, Oddo, and Babat. Again, feel free to give me a call.
And you'll come back whenever I want you to.
I'd love to.
If I just snap, you're going to come.
I'm here.
All right. Listen. Good luck this year. I know it's a big year. You know, we've had other presidents from the trial lawyers here, and it's a lot of work. But you know what? I think they got the right guy for the job.
I appreciate that. Thank you.
All right, thank you. All right, hang on. All right. Well, that's all the time we have for today. I'd like to thank our wonderful guests for joining us, and of course you, the viewers, for watching. If you missed any part of today's show, be sure to check it out at www.bronxnet.tv. Also remember, if there is a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesch@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag Ask Today's Verdict if you have a question. For myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach a verdict. We'll see you next time.
Most party fouls are pretty dumb. But if you decide to drink and drive underage, you could lose your license and your freedom. Underage drinking and driving. The ultimate party foul.
Leaving hot coals improperly extinguished can cause a wildfire.
Hey guys, it's Smokey!
It looks as if Smokey is going to use the drown, stir, drown, and feel technique. After the first drown, a good start. Next, another drink. And finally, a close feel.
Is it cool? Okay.
Yeah.
Hey, Smokey, catch! Oh, my bad, Smokey.
Only you can prevent wildfires.
Maria, so how's work?
It was fourth period biology. Our students just weren't getting how easily viruses spread. So Miss Bella and I had them role play a zombie virus outbreak. By the time they had all learned the lesson, all the living were dead. Hey, how's your job going?
That big sales meeting I planned? Next year, I might get to go.
Cool.